Hello and welcome to the Minimum Competence episode for Tuesday, October 22nd, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we discuss the legality of Elon Musk's $1 million election giveaway, Carrier Global's $730 million PFAS settlement, Murdoch's Dow Jones lawsuit against Perplexity AI, Michigan's overseas voting case, and the need for uniform sales tax laws. Let's remember, the good news is that some of the bad news can be turned into good news when you change your attitude and read today's legal news. On this day in legal history, October 23rd, 1987, the U.S. Senate rejected President Ronald Reagan's nomination of Robert H. Bork to the Supreme Court by a vote of 42 to 58. This rejection was a pivotal moment in U.S. legal and political history, marking one of the most contentious Supreme Court nomination battles. Bork, a former Solicitor General and judge on the D.C. Circuit Court of Appeals, was known for his strict originalist interpretation of the Constitution, which raised concerns about how his judicial philosophy might affect rulings on civil rights, privacy, and women's rights. Bork's nomination ignited intense public opposition, particularly from civil rights organizations, women's rights groups, and liberal advocacy organizations. These groups feared that his conservative views on issues like abortion, affirmative action, and privacy rights would roll back decades of legal progress. His academic writings and controversial role in the Saturday Night Massacre during the Watergate scandal, when he followed President Nixon's orders to fire the special prosecutor investigating the case, further fueled opposition. The Senate's rejection of Bork is widely seen as a turning point in the politicization of the Supreme Court's nominations, where ideology became a key battleground. The term borking was coined to describe the aggressive campaigning and lobbying used to derail a judicial nomination. This event reshaped how future judicial nominations would be approached, with increased scrutiny on nominees' legal philosophies and the political states of Supreme Court appointments. Elon Musk's $1 million election giveaway has sparked debate over whether it violates federal laws prohibiting payment to register or vote. The giveaway, which selects daily winners from those who sign Musk's petition supporting the First and Second Amendments, targets key battleground states ahead of the 2024 U.S. presidential election. Legal experts are split on its legality. Some argue that it could be viewed as indirectly incentivizing voter registration, particularly since participants must be registered voters in specific states. Critics, including Pennsylvania's Governor Josh Shapiro, are calling for investigations, citing concerns about potential violations. Others, like former Federal Election Commission Chair Brad Smith, believe Musk is not violating the law because signing the petition isn't directly tied to registering to vote. The controversy centers on whether Musk's actions are a clever mobilization tactic or a breach of election law. Carrier Global has agreed to a $730 million settlement related to PFAS contamination claims against its bankrupt fire protection unit, Kidde Fenwel. The settlement will resolve lawsuits over toxic chemicals known as PFAS or forever chemicals found in Kidde Fenwel's firefighting foam products, which allegedly polluted water and soil near U.S. airports and military bases. The settlement allocates $540 million to Kidde Fenwel and $190 million to the plaintiffs. Carrier will fund $615 million over 5 years and use $115 million from the sale of Kidde Fenwel's assets. Additionally, Carrier expects up to $2.4 billion in insurance payouts to cover costs. Kidde Fenwel filed for bankruptcy in May of 2023 amid over 4,400 PFAS-related lawsuits. This settlement follows other major PFAS agreements, such as 3M's $10.3 billion and DuPont's $1.19 billion settlements. Rupert Murdoch's Dow Jones and the New York Post have filed a lawsuit against Perplexity AI, accusing the startup of illegally copying their copyrighted content to generate AI-based responses. The lawsuit highlights a broader conflict between publishers and tech companies over the unauthorized use of copyrighted material for AI training and content generation. Perplexity, which competes in the search engine market, provides AI-generated summaries from various sources, including material from Dow Jones and the New York Post. The lawsuit claims the Perplexity system reproduces content verbatim and without permission, constituting copyright infringement. Dow Jones and the New York Post seek to stop Perplexity from using their content and demand the destruction of databases built using their work. Despite attempts to negotiate a licensing deal, Perplexity did not respond. The case reflects growing tensions between media organizations and AI companies as publishers push for compensation for the use of their content. A Michigan judge rejected a Republican effort to restrict overseas voting in the state. The Republican National Committee had filed a lawsuit claiming Michigan's election laws improperly allowed U.S. citizens living abroad who had never resided in the state but had relatives there to vote. Judge Seema Patel ruled that the challenged language in the law aligns with federal and state regulations. According to Michigan law, U.S. citizens who have never lived in the U.S. can vote in Michigan if a parent, guardian, or spouse last resided there, as long as they haven't registered in another state. The RNC did not immediately respond to the decision. And in my column for Bloomberg this week, I argued for the need to establish a uniform sales tax system across states to alleviate the burdens on small businesses and remote sellers selling in multiple states. The current fragmented system with over 13,000 tax jurisdictions creates significant compliance challenges. Since the Supreme Court's South Dakota v. Wayfair decision in 2018, remote sellers are now required to navigate a complex patchwork of tax rules across states, which hampers interstate commerce. A proposal by Senator Maggie Hassan to standardize sales tax policies has drawn opposition from states concerned about losing autonomy, but the economic harm caused by the status quo warrants congressional intervention, at least in my opinion. Small businesses are disproportionately affected, as they are often required to track taxes across multiple states, increasing administrative costs. A federal solution like Hassan's proposal could simplify this with exemptions for small sellers and protections for good faith tax collection errors. Offering federal incentives for states to modernize their tax systems could help ease the transition. By building on existing frameworks, such as the Streamlined Sales and Use Tax Agreement, a collaborative approach can balance state sovereignty with the need for a more consistent tax system that supports commerce. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than minimum competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, if you look for the good in people expecting to find it, you surely will.